Hi, good evening, everybody. My name is Philip Newsden, and I'm pleased to welcome you to tonight's author lecture series. I'm an alumni from the Stern Business School undergraduate class of 2012. I serve on the Alumni Council as Vice Chair of Signature Events, and I'm very glad to see a lot of alumni and current students here today with us. And it is my distinct pleasure to announce and present our speakers this evening. Jesse Eisinger, author of the recently published book, The Chickenshit Club, Why the Justice Department Fails to Prosecute Executives, in conversation this evening with Professor Paul Zarowin, Director of NYU Stern's Vincent C. Ross Institute of Accounting Research. Just a little bit about Jesse's background. He's a senior reporter and editor at ProPublica. His work has appeared in the New York Times, the Atlantic, the New Yorker, the Washington Post, the Baffler, the American Prospect, and on NPR. Before joining ProPublica, he was a Wall Street editor at Condé Nast Portfolio and a columnist for the Wall Street Journal covering markets and finance. In April 2011, he and a colleague won the Pulitzer Prize for national reporting for a series of stories on questionable Wall Street practices that helped make the financial crisis the worst since the Great Depression. In 2015, he won the Gerald Loeb Award for commentary, and he has also twice been a finalist for the Goldsmith Prize for investigative reporting. Our moderator this evening is Professor Paul Zarowin, Director of the Ross Institute here at Stern. He has won numerous research awards, including the New York University Presidential Fellowship, the Pete Morwick National Research Fellowship, and the Gluckman Institute Fellowship. Professor Zarowin's research focuses on the relation between the stock market prices and financial accounting data. He has studied how and why this relation varies over time and across firms, and how factors such as firms, regulators, and the economic environment affect this relation. Professor Zarowin's recent work deals with the extent to which stock prices reflect firms' future prospects and how this is affected by firms' disclosures, accounting choices, and regulations. The Chickenshit Club was originally published in the summer of 2017 and has been a favorite among academics and industry experts alike, having won the 2018 Excellence in Financial Journalism Award. This book provides a detailed explanation of the history and context of the evolution of the Justice Department's approach to pursuing corporate criminals. And thank you to both for being here with us this evening, and we are now honored to have you. And now, please let me hand over the stage to you.
Okay, thank you all for coming, and we couldn't have asked for a more fortuitous time to hold this event. When we planned it, obviously we couldn't know what was going to happen in the last couple of days, and especially today, but hopefully we'll get into some of those issues in a short while. But it's certainly a great time to hold this. I want to thank Jesse for coming here, and it's just an example of the kind of intellectual energy that we have here at the Stern School and the impacts that our events have. So let me get right to the questions. Okay, so some in the audience might not be familiar with the book or the events it describes. So if you could, in a nutshell, describe how you got interested in this and kind of take us through the book a little bit.
Sure, happy to. And thanks so much for coming, and thanks for the Stern School for inviting me, and thanks to Matt Rudder for spearheading this. I'm always happy to have an audience where almost no one sits in the front row. I feel like they're not going to be ready to pounce on my every word and error, so I like that. I was inspired to write the book because I covered the financial crisis, and I wrote about things that I thought were wrong that bankers had done related to the CDO business, the collateralized debt obligation business, which was a kind of mortgage security that was really at the nexus of the crisis. And we thought we'd uncovered a lot of activity that could be described as criminal. And so after we wrote those stories, I waited around for some of the prosecutions. I also thought that bankers had lied and other things that didn't have to do with my coverage. And I waited, and they didn't come. And that seemed like a puzzle to me. And I ended up writing a couple of columns about this for the New York Times, and it really plagued me. And then I started noticing that we were really in something of a white-collar prosecution crisis. And so I delved into it further with a Times article, Times Magazine article, and then the book. And the thesis of the book is that CEOs commit crimes. I think that's a relatively uncontroversial thesis. but we don't seem to prosecute them anymore in this country at large companies. So over the last decade, in fact, 11 years dating to the financial crisis, I can think of only one Fortune 500 company CEO who's been indicted, no COOs, no CFOs. So of those many thousand men and women in the country who serve in those positions, did no one commit any crimes? I find that highly unlikely. So what I'm looking for is a different explanation for what's going on, why those people aren't being prosecuted. Do they not really commit any provable crimes, or have they committed provable crimes and are not being prosecuted for some other reason? And I end up arguing in the book, the thesis of the book is that we have lost the will and ability to prosecute top corporate executives. And it is an argument that I place as a kind of backlash to the prosecutions of the Enron era frauds, the era of frauds in the late 1990s, early 2000s. And we can get into it because it's a complicated set of factors that lead to this Department of Justice inability now, the kind of ineptitude and unwillingness and somewhat corruption that has led to this inability to prosecute top corporate executives.
Very interesting, very interesting. So developing that a little bit, there's a lot of interesting characters, if I may say, that you develop in the book, people who play major roles. Could you talk about maybe one or two of the most significant, in your opinion, really caught your interest, individuals in the story? Yeah,
well, so this is not an academic account. And it's not a legal brief, it's a journalistic account. And so I build it around characters who I'm attempting to make interesting to the reader. And there are a couple of heroes in the book. One is a federal judge in the Southern District, Judge Jed Rakoff, and another is a prosecutor who comes through the Miami office, federal prosecutor, who is there during the financial crisis at Main Justice, which is the nickname for the central office of the Department of Justice in Washington. And he's an executive, an official at Main Justice who has overseen a lot of white-collar prosecutions, and he is an ornery and big character named Paul Pelletier. He is foul-mouthed. You basically can't get a sentence out of him without 17 swear words, which is it's a slight homage to him that I've put a swear word in the book title, although the title comes from a Jim Comey line, which we can get into in a second. But so Pelletier is a guy who grew up in a working class family in Boston, and it's kind of remarkable that he managed to graduate high school, much less become a federal prosecutor. He was driving around as a kid drunk, and one time they decided to cross state lines to go to a bar with his buddy in high school, and they turn off the lights and go on the back streets because they're driving drunk and they don't want to be stopped by the cops. This is the kind of logic of a high school kid. And they do end up getting stopped by the cops, and he's arrested, and his father has to bail him out, and his older brother comes in the car, and so they're driving home, and the brother says very innocently, "Dad, I smell something. Do you think Paul has been drinking?" And the father goes ballistic. And so, he's a kind of ne'er-do-well who ends up becoming a kind of remarkable prosecutor with great instincts. And he's a counterpoint to the kind of buttoned-down, technocratic Obama prosecutors who have come by and large from big law firms who've come back to the Department of Justice and have been representing corporations, defending corporations. Eric Holder, who worked at Covington, Lanny Brewer is the head of the criminal division of the Department of Justice, who worked at Covington, Mary Jo White, who's the head of the SEC for Obama, who worked at Debevoise and Plimpton, and they clash with the Pelletiers of the world. And Pelletier has had experience and has instincts and is great in trial, great with juries, and has prosecuted top executives, and he's sort of emblematic of a kind of lost skill set and a kind of technocratic ethos that takes over the Department of Justice. The short version of what's happened at the DOJ is, for a lot of reasons, prosecutors have lost tools, and there's been a de-emphasis on white-collar investigations and prosecutions, and there have been a lot of bad rulings, and there have been a lot of fiascos, losses at the DOJ. And because of all those things, they've become gun-shy about investigating and prosecuting individuals. What they've turned to is settling with corporations for money. And so the way we prosecute and enforce corporate law wrongdoing in this country is we settle with corporations for big fines. They're actually not very big, but they grab big headlines. And this is a system that I argue is broken.
Can you talk a little bit about Rakoff, because you mentioned him?
So Rakoff is the product of this system. He was a young prosecutor in the Southern District, which is the best office of the Department of Justice. They're the smartest and best prosecutors in the land, and the reason you know that is you ask any alumnus of the office, they'll tell you that they were the smartest and best lawyers. And Rakoff comes up in an era right after the legendary Robert Morgenthau has left the office. He's become the DA, Manhattan DA, but it's got a lot of Morgenthau DNA in the place. And Morgenthau was really by and large, what I argue is there's never been a golden age where we've really done this well, where we prosecute, where rich and powerful people have had to fear for their liberty if they took a step wrong. But Morgenthau really wanted to prosecute CEOs, and he wanted to raise the caliber of white-collar criminal that they were going after. So there's a lot of DNA in from him in the office when Rakoff is at the SDNY. Then he becomes a white-collar defense lawyer. Then he becomes a judge. He's appointed by Clinton to become a judge. He's really a product of the system, regarded as one of the most brilliant district court judges in the country, but no radical by any means. And I argue, he would maybe object to this, I argue that the financial crisis radicalizes him. When he sees the SEC going soft, first on Bank of America in its takeover of Merrill Lynch, where Bank of America seems to have lied both to the public about Merrill Lynch's losses and the bonuses that they were paying to Merrill Lynch executives, and then Citigroup about a CDO. He's angered and deeply troubled by the SEC's lenience in it. And what he does something very unusual for a judge. He rejects an SEC settlement. He rejects these two SEC settlements. And judges didn't do that. They usually rubber stamped them and deferred to the SEC and deferred to regulators and their judgment. And Rakoff said no. And Rakoff started to realize that there is a kind of crisis here. So he is another moral center of the story, as a guy who is radicalized to see this failing at the government level, and troubled by it, and tried to do something. And he's really he's really sort of defeated. This is not anybody wanting to come to my book for a happy ending will not get it. There are no happy endings here. And it's only gotten worse in the Trump administration. But Rakoff sort of wins a few battles and wins the argument and the moral war, I think, but actually loses on the substantive legal grounds.
So both of them are sort of like Don Quixotes, in a sense.
Yeah, they are. I regard them something of tragic heroes. Pelletier, in particular, is a guy whose whole career is dedicated to public service, who's a true prosecutor to his bones. And he really is drummed out of the Department of Justice by the Obama people, who just can't stand him and don't like his approach and think he's dangerous, think he's a cowboy. And the end of the book, toward the end of the book, I write about his retirement party. And hundreds of people come to his retirement party. He's beloved by not just his fellow prosecutors, but by all the staff in the building. He's the kind of guy who, he would have a trial. There was a trial that he did of some crooked doctors in Florida. And after the trial, one of the defendants came up and he was convicted, and then he hugged Pelletier. The guy, he's the kind of guy who, people had this kind of crazy loyalty to him, and so hundreds of people come, and there's this kind of epic retirement party. But it's incredibly bittersweet because he's losing the job that he loves. And so, my book, to the extent that I have heroes in it, they're tragic heroes.
Tragic heroes, very interesting. So you alluded before to the fact that prosecutions have been replaced with financial settlements. So two of the ones that you mentioned in the book are consent decrees and deferred prosecution agreements. So those seem to take on a very important role in the way white-collar crime is prosecuted. Can you talk about them, consent decrees and deferred prosecution agreements?
Yeah, so the deferred prosecution agreement is something that is invented by the Southern District, by Mary Jo White when she's the U.S. Attorney in the Southern District in the 90s, in a completely unplanned, haphazard way. It's kind of regarded as a one-off. What it is a kind of funny thing where they say, we're prosecuting you, but we're not prosecuting you. We're prosecuting you, but you, corporation, but we're going to defer it. We're going to put it in a drawer. Don't do anything bad again. You promise. And the corporation says, yes, we promise. And so we're not going to take you to trial. We're not going to convict you. We're not going to have a guilty plea. And then we can pull it out of the drawer if you do something wrong again. And they think of this as a kind of one-off for the special situation that they're involved with. And it's an outgrowth of something that another hero of the book, Stanley Sporkin, has created, or not created exactly, but has kind of popularized for the SEC, which is the consent decree, which is a no admit, no deny agreement that Sporkin uses as the enforcement director in the 1970s at the SEC. Sporkin, as I say, another big character in the book, is a larger-than-life figure, kind of oddly enough, like one of the most powerful bureaucrats in Washington throughout the 1970s, more powerful than any chair of the SEC in that decade, protected by Congress. He's a Republican, but he's protected by Democrats like William Proxmire, a senator from Wisconsin, terrorizes corporations. And he's reaching a lot of these settlements, but it's a very powerful tool in his hands because he's a kind of steely-eyed, serious-minded regulator. It becomes corrupted over time. And becomes toothless over time, and becomes de rigueur to only reach no admit, no deny settlements at the SEC, which is the kind of thing that Rakoff objects to. The DPA, I'll give you a little bit of, so in the first decade of the DPAs, the Department of Justice does about 18 of them. It's with corporations. Since the early 2000s to today, they've done 430 of them. And in doing these DPAs, they have stopped really, as I've argued, as I've said already, prosecuting top executives at the largest companies. So this has really replaced these DPAs, and now sometimes they reach NPAs, non-prosecution agreements, which have slight differences, semantic differences, I think. Sometimes now they even reach guilty pleas with corporations. The guilty pleas are really substance-free because the companies are protected from the consequences of the guilty pleas by the Department of Justice sort of going around to the regulators and making sure that they're not going to pull licenses and things like that. So you saw a bank like Credit Suisse plead guilty, but to crimes, but it didn't get its banking license pulled, so it could go on. So these settlements, there's a big problem with them. My central argument is that they just simply do not work. What I mean is they do not curb corporate crime. They do not prevent or deter corporate crime. And you can see this because you see corporations entering into every type of settlement known to the imagination of prosecutors and regulators, and going on to committing other crimes. Pfizer, J.P. Morgan, BP.
After they enter
after they have entered into. So Pfizer has a subsidiary has pled guilty. It's reached an NPA. It's reached a DPA, and it still has entered into multiple DPAs and NPAs and settlements with regulators. Wells Fargo, J.P. Morgan. The list goes on and on. This is not something that prevents corporate crime. And my argument is that prosecutions of individuals is the single best deterrent for corporate crime. That executives have a stake in society, a stake in preserving their own reputations. They're very well informed about the world, and they would pay attention if one of their colleagues were to be prosecuted. It's the kind of thing that they would seek to avoid. Now, there's no perfect deterrent for corporate crime, but corporate crime is really a choice. These people have a lot of leeway and a lot of moments where they can either lie or not lie. They can take their medicine or not take their medicine. They haven't met their sales targets. There's a choice. Do we move the trucks off the lot and count it as sale or not? And if you raise the incremental costs of it by prosecuting some of these people, you will reduce the crime. That's an argument.
Do you see any evidence that we might be heading in that direction? Are you at all hopeful?
No, I'm not hopeful at all. I am the opposite hopeful, and I think the Trump administration is going in the opposite direction, which is that we're seeing now something of a regulatory strike and a prosecutorial strike. The SEC fines are down about 90%. The CFPB, the Consumer Financial Protection Bureau, investigative and enforcement operations are being gutted. The Department of Justice is not prosecuting top executives, although there was one recently. So there's like glimmers of hope here and there. But largely what we're seeing is there's been some talk of prosecuting individuals from Jay Clayton at the SEC. It is traditionally a Republican idea or a Republican ethos or approach to focus on individual prosecutions. In fact, one of the reasons why I think the Obama administration was such a spectacular failure in this area is that Democrats and liberals have historically undervalued the value of prosecutions, arguing that you're just getting bad apples. And so the heroes, a lot of the heroes in my book turn out to be Republicans. There's another one who's the Deputy Attorney General in under Ashcroft in the Bush administration, Larry Thompson. Turns out another figure I consider really interesting. He's a guy who grows up in segregated Missouri. He's African American, becomes a Goldwater Republican, rises through the kind of Republican ranks to become Deputy Attorney General under John Ashcroft, and George Bush is no person's idea of a kind of serious reformer or anyone who it would be surprising to people that he was serious about cracking down on corporate crime. But Larry Thompson takes it very seriously and regards it as an outrage that corporate criminals are treated differently than street criminals, particularly people of color or the poor. And so he takes prosecuting the Enron era prosecutions very seriously. So that's all to say that Republicans have drifted from this law and order ethos and now have been overtaken by a kind of, I think, a corporate crony outlook or ethos, and they've drifted away from prosecuting individuals, which has gotten away from the kind of grounding in this kind of old line law and order, making capitalism safe for capitalists by prosecuting rotten actors.
Very interesting. So there's a term you use in the book which you borrow from biology. You call it the ecosystem of corporate fraud. Could you go into that term a little?
Yeah, sure. So this is really kind of Sporkin's insight that I think is very important, which is that to say that fraud thrives in an atmosphere of permissiveness, and that there are key gatekeepers at many points. And Sporkin focuses on three main gatekeepers: the accountants, the lawyers, and the investment bankers. And Sporkin's idea is you do much more good if you go after those guys and prosecute or charge them civilly, because the SEC has civil powers. He worked a lot with the DOJ. But if you go and sort of cut off the gatekeepers or prosecute them, they're going to crack down and do a lot of good and oversee their clients, and there'll be a reduction in the corporate fraud at the underlying companies. So he's quite productive at that, and they actually prosecute a bunch of lawyers and accountants who have enabled some of the major accounting frauds in the 1970s. That ethos sort of goes away, and by the time you get to the pandemic of accounting fraud in corporate America in the late 1990s, the accounting firms in particular have lost their way. And then there's a big prosecution of Arthur Andersen in the wake of the Enron prosecutions. And so Larry Thompson and a guy named, you may have heard of him, he's sort of lost to the sands of time, Bob Muller. He is the head of the FBI at the time. He and Thompson create the Enron Task Force, which is a group of prosecutors who are sort of locked in a room, not literally, but it feels that way, and they focus just on the Enron prosecution. This is something that the Obama administration and the late Bush administration did not do for the financial crisis, and I think is a terrible tactical and strategic mistake to have not created task forces to go after the complex crimes that were involved in the financial crisis. But so a group of prosecutors only focus on Enron and the ancillary prosecutions of the Enron fraud, which include prosecuting the firm of Arthur Andersen. And what I do in the book is try to rehabilitate this prosecution because it has become understood almost universally as a disastrous mistake that should never have been undertaken and was wrong on the merits. And it's not just accountants at Arthur Andersen, partners who think this, but it's kind of widely shared, not just by the Wall Street Journal editorial page and the Chamber of Commerce, which argue this, but also by Obama appointees. Mary Jo White and Lanny Brewer are interviewed and say the Arthur Andersen prosecution was a terrible mistake. So what I argue is that Andersen was not just the handmaiden to Enron's fraud in a way that was much more serious than is remembered, but had been the enabler of multiple corporate frauds in the lead up to this, and was actually under SEC consent decree for the biggest accounting fraud at that to date before Enron, which was waste management, but also had been involved in Boston Chicken and Sunbeam and the largest nonprofit accounting fraud at the time, a serial. It had all the accounting firms who were deeply troubled and had lost their way, but Arthur Andersen was the possibly the worst. So I think that prosecution was legitimate. What I argue in the book is that prosecutions of corporations should be a last resort, that prosecutions of individuals should be the focus of prosecutors. But I don't think that they should eschew prosecutions of corporations entirely, which they essentially have done. They've essentially decided after Arthur Andersen, which for a variety of reasons, it's a little complicated, but one of the reasons is that on something of a technicality, the Supreme Court overturned the prosecution. And Arthur Andersen went out of business, and a lot of people blamed the prosecution for Arthur Andersen's going out of business. I don't think it was going out of business solely. I think it was inevitably going out of business, and that the prosecution only maybe accelerated things. But for a variety of reasons, they've decided not only was that a mistake, but we cannot really prosecute large corporations anymore and take them to trial and have the consequences of a loss on those corporations' heads because of what has become known as the too big to fail or too big to jail problem. And the Obama administration has absorbed this idea, this wrong-headed idea, and the consequences are that we don't prosecute companies or individuals.
So another point that you make in the book, which I found really fascinating, you talk about the Supreme Court, and you say that between the members of the Supreme Court who are on the left versus the right, in terms of social issues, there's a vast ideological gap. I think most people would agree with that. But when it comes to business issues, you seem to think there's no gap between them. And I found that very interesting, and most people probably are not aware of that. Could you talk about that a little bit?
Yeah, well, liberals have essentially traded social gains on things like gay marriage, protection of affirmative action, social causes for, they've traded that for corporate enforcement. And so people like Breyer and Ginsburg on the courts have been quite corporate friendly. And the rise of the kind of Clinton era, Obama era technocratic, democratic ethos, and the kind of the background that they have come from, a kind of white collar bar background, has given rise to some democratic lawyers and judges and justices who turn out to be very friendly to corporations, and have voted to some extent for things like upholding arbitration agreements, stripping consumers of their ability to challenge arbitration agreements, throwing out in the prosecution of Jeff Skilling, who was the CEO of Enron. One of the charges they prosecuted him was honest services, and this was something that was kind of remarkably imaginative use of a statute that had been used in public corruption cases, where they charged people in public corruption with depriving the people of their honest services. And that was even if you weren't benefiting directly from something wrong. You were facilitating a bribe or a payoff, but you weren't benefiting as mayor from it. You could be charged with a crime. And they transferred this to say that CEOs or top executives could also be prosecuted. And the Supreme Court is kind of energized by this transference from the public sphere to the private sector, and concerned about it. This is a kind of cause célèbre from the Journal editorial page and the Chamber of Commerce and right-wing think tanks and the Federal Society, and it brings to the Supreme Court. The Supreme Court throws it out. But Democratic judges support that by and large.
That's very interesting, because we tend to think on the Supreme Court that there was this great divide in social issues, yes, but in business issues, no.
Much overstated.
Much overstated. Very interesting. One of the points you make near the end of the book, you say the U.S. has lost the ability to punish the powerful. I think that's a very powerful line, to borrow your word. Do you see any or have any hope that may change going forward?
Well, I don't, and I think that the point of the book is that what are we talking about when we talk about the lack of prosecutions of CEOs? we're talking about having a two-tiered justice system in this country. And I think a lot of people are aware that we have over-criminalization of certain crimes like nonviolent drug possession, that we have a mass incarceration problem in the country, that this has disproportionately fallen on the poor and people of color. And my book is about the flip side of this, which is that we have impunity for certain class of wealthy and powerful. And in fact, when we talk about inequality in this country, we're often talking about wealth and income inequality, but I think the greatest perquisite of being wealthy and powerful in this country is the impunity to commit crimes. And this is a threat to democracy. It is a threat to the basic legitimacy of our legal system and the rule of law, and that people understand it and perceive it and recognize it. And it undermines the legitimacy of our system. So I think that it matters. And that's the argument that I'm trying to convey, that it is about having a fair and just society, that everyone, if they break the law, can be subject to fair and just and serious prosecution.
So you wrote the book in 2015, I think you said?
Yeah.
And obviously a lot has happened since then with the election and obviously what's going on the last couple of days as we speak.
Does it have anything to do with white-collar crime?
I think so. So if you were kind of bringing the book up to date, if you were adding another couple of chapters, let's say, or putting the book in or putting the events that we've seen in the last couple of days or few weeks in the context of the book, kind of bring that stuff in.
Sure. So, first of all, I think that Muller has exposed a number of extremely important and troubling aspects of white-collar enforcement in this country. I think that you can see through the Mueller investigation and prosecutions that whole swaths of the economy are severely under-policed. And my book is about the prosecutions at the large corporate level and what's happened with them. But I think I understated the problem, because you can see that high-end real estate and corporate lobbying and campaign finance were relatively basically unpoliced until Mueller. And you can see what the reason why Mueller is effective is that he's got a team of people who are just solely focused on this one question, and they're highly skilled, so you got to pick the best of the best. And they have a kind of focused mandate, and he's using very aggressive tactics, which is another thing that they've started to eschew in the last decade. They've gotten away from kind of historically aggressive tactics, particularly with white-collar criminals. So I think that's one of the big lessons. The other big lesson is that if we had a serious white-collar enforcement effort, there's no way that Donald Trump would be president of the United States. The New York Times has demonstrated beyond any reasonable doubt that Fred Trump and Donald Trump committed tax fraud for years. If we had a serious IRS effort and concurrent prosecutorial effort, it's almost impossible to imagine that he would have been president. We broke a story that Ivanka Trump and Donald Trump Jr. were investigated for criminal fraud in the selling of the Trump Soho. They made material misrepresentations of the Trump Soho, and the Manhattan DA's office, Cyrus Vance, investigated. And in fact, all the prosecutors who were involved in that investigation wanted to bring charges against Donald Trump's son and daughter. And Vance overruled them. Vance overruled them after having received a very big donation from Mark Kasowitz for his reelection campaign. Mark Kasowitz was Donald Trump's personal lawyer. He says that didn't influence him. But he overruled the prosecutors and decided not to bring those charges. So I think that white-collar criminal enforcement matters at the national level, and that's what we're seeing now.
Wow, very interesting. Well, we're just about at the end, so let's give Jesse a big hand. Extremely interesting talk, and we're going to open it up to questions from the audience. So we have one here. Just when you have a question, please raise your hand and make sure to wait for the mic to come around so everyone can hear you.
You've made a compelling assertion as to the rampant nature of criminal conduct among American CEOs. Who would be your top 5 targets for indictment?
Yes. I get this question a lot, and I have a dodge for it, not surprisingly, which is, one, the book is not a legal brief, so I don't lay out a case. I'm not a lawyer, so that wasn't really the point of the book. The point of the book was to argue that things have changed with our approach, and also to identify the fact that if you don't look for criminals, you can't find them. And we didn't look in the wake of the financial crisis in any concerted or serious way. And I use as a couple of examples, one example in the book, and I, of course, encourage everybody to buy the book. You don't have to read the book, but everybody should buy it. There's a chapter on the Lehman Brothers investigation. And the Lehman Brothers investigation is Lehman Brothers collapses spectacularly in September 2008. There's no too big to jail problem because the corporation has gone under. 3 offices of the Department of Justice opened investigations, but in the end, it sort of falls weirdly by the wayside. And it falls actually to just one prosecutor in the Southern District who it's not even her full-time job to look at the Lehman Brothers prosecutions. She's got 3 or 4 other cases on her plate. Not surprisingly, that's not the way to approach these cases. So I think you could have made cases against dozens of CDO bankers. I think you could have possibly brought cases against the CEO of Bank of America for misrepresentations of the Lehman investigation. That was criminally investigated. You could bring a case against Lehman Brothers top executives, COO, CFO for misrepresentations on the bank loans, on the cash flow statements. Their liquidity representations were probably, I argue, were regarded as criminal by the bankruptcy lawyers who were investigating that. I think that there are a host of charges that you could have brought against AIG executives. But the point of the book is not to make an individual case on an individual executive, but to say that there's a systemic problem here.
Thank you. Very interesting. I share your pessimism, and I want to see if you would agree. I think we're in an environment now, I mean, even post-Trump, where the values of our country are so based on these, if you want to call it the basic bread and butter issues of, do I have a job? Do I have security? That there really will be no reason to focus on corporate crime in any real meaningful way if the view is, what's really important is we create jobs. The GDP grows. We have a stable economy. And I see the problem getting even worse because we live in such a volatile, challenging environment. So why is the individual person going to care about, they may complain about the fact that this guy's a crook, but isn't it kind of baked in as long as they have a job, they're doing well, their family's doing well? It's a pretty pessimistic view, but I think if anything, it's going to get worse. Would you agree?
I basically do agree. I think that's a valid point that the average person, the economy is particularly unstable and uncertain, and that people are struggling. The average American is struggling and very busy and not paying attention to the details. I think that viscerally, they understand that there's a troubling system. If you went into any bar in America and asked the person, next to you, what's the one thing you know about the financial crisis, they'd say nobody went to jail. That is the salient takeaway. Nobody was held accountable. So people know it, and they understand it. And there's a corrupting aspect to not holding people accountable, especially because the Obama administration did not bail out homeowners nearly to the extent that they bailed out bankers. And people understand that. They might not understand exactly what the TARP did, or the distinction between the TARP and the stimulus, or what the difference between HAMP and HARP was, but they understand that homeowners didn't get a bailout, and bankers did. That's largely true, and and then they understand that people weren't held accountable. So I think that it's not difficult to change the ethos at the Department of Justice. You could fund it better, and you could change the approach, change the incentive structure. We didn't talk about the revolving door. It's a big problem. It's something that I address in the book. But you could change these things, but it would take a concerted effort, and it would take a change in approach. And certainly the Trump administration, DOJ, is not changing it anytime soon.
My question is twofold. One is, and I think you touched upon it seconds ago, what remedies do you fathom would be effective in, shall I say, putting some steel in the spine of DOJ? That's number one. And number two, how do you go about keeping career prosecutors who are, shall I say, inventive and aggressive at DOJ? Because, as we all know, government service pays a hell of a lot less than Covington and Burling and Cravath Swain, et cetera.
Yeah. So both those questions are intertwined. So what we didn't really talk about is how corporate law enforcement works, and it's really important to understand it, which is basically that the Department of Justice, the U.S. government, has outsourced and privatized investigating corporate wrongdoing. And we have outsourced and privatized it to the corporations themselves. They hire law firms to do internal investigations. It's kind of like if, say, the President of the United States were being investigated for colluding with the Russian government to cheat and win the election, and he hired Rudy Giuliani's firm to investigate the question. You wouldn't really be optimistic about the answers getting to the truth. And that's what happens every day in corporate law enforcement. And it's worse than that, because what happens is the internal investigations are produced by Cravath or Paul Weiss or one of the Covington, and they are delivered to the Department of Justice, and the prosecutors can do an investigation separately than that, but they really rely on this. And they negotiate the DPA. And who are they negotiating with? Well, they're negotiating with lawyers for firms that they aspire to go work for. So the Department of Justice today has become a training ground for future defense lawyer partners at major corporate law firms. That's where 90% of young prosecutors go after the Department of Justice, after 8 years. So you have to break this cycle. And you have to break it by, it's not easy to do, but you'd have to break it by two things. One is you need to, if you're the DOJ, eschew reliance on internal investigations. You don't have to rely on internal investigations because you've got grand juries, you've got subpoenas, you've got sting operations, wiretaps. You have all sorts of investigative techniques that are not dependent on internal investigations, which are studiously and curious about culpability of the top individuals. So you need to break that reliance, which means it's a lot harder to do those investigations. It's a lot more time consuming. It's much more risky for any individual prosecutor to do because he or she is not going to be able to produce something in 2 or 3 years necessarily that will show an accomplishment, will get your stipple drawing in the Wall Street Journal for having reached the $13 billion settlement with JP Morgan. So you need to change the incentive structure and the internal, the way that the Department of Justice functions, and allow them to fail and allow them to. The point of the Chickenshit Club title is, it comes from a Jim Comey speech, who says, how many of you guys have never lost a case, giving a speech to a bunch of prosecutors? A bunch of hands shoot up. He says, you're the Chickenshit Club because you're afraid to lose a case. You cannot be afraid to take on powerful interests, and sometimes justice can be done even if you lose a case. So they have to change the incentive structure so that young prosecutors can take on difficult cases against individuals and potentially lose them. So that's the first thing. And the second thing is they need to recruit differently, recruit from plaintiffs' firms, recruit from around the country, not six elite law schools. Try to reduce the number of people who are coming from corporate defense firms or going to corporate defense firms. You do academics, public interest lawyers, and then, in a perfect world, which, if I were czar, I'd pay them a lot more. You're never going to compete with the private sector, but you don't have to, because a lot of prosecutors love their job and they would do it for the rest of their lives or for a much longer time than they do, but they can't because they can't they can't live on a prosecutor's salary in the most affluent cities in America. Prosecutors are highly educated, some of the smartest, most able people in America. They should live affluent lifestyles in the most expensive cities in the country. I'd pay them, if we paid them $450,000 a year, it's nothing compared to a private sector salary, but they would live nicely, handsomely on that and stay and work very hard for the government.
Hi, good evening. Earlier you mentioned the impact of corporate hires on the Obama administration in the DOJ. What about Tim Geithner's role as Secretary of the Treasury during that whole time?
Yeah, so I never uncovered. So Geithner is obviously an incredibly fascinating, important figure, incredibly influential in the Obama administration. I never uncovered him giving the order to Eric Holder, and I don't think this exists, where he said, "Don't prosecute the banks." But and of course, what's really interesting about Geithner is that. Through the financial crisis, he's never worked at a bank. He's not a banker. He's a career civil servant. But what he does is he has the ethos of the Obama administration, I believe, a kind of technocratic, democratic ethos where he famously says, we don't want to have Old Testament justice. What I think he means by that is we don't want to succumb to the mob with their pitchforks and prosecute a few bad apples to placate this mob with kangaroo courts. This is a systemic problem. It's a systemic problem which has complicated regulatory failures, and we need to address that, and we need to address that in a kind of precise and all-encompassing way. So we're going to create Dodd-Frank. And Dodd-Frank is going to touch every corner of the financial world with an incredibly precisely written, incredibly intelligent regulation that will deal with mortgage reform here and derivatives here, et cetera, et cetera. And I think that's just the wrong approach. It's the wrong approach for two reasons. One is that bankers are smarter even than Tim Geithner. Tim Geithner is a really smart guy. Bankers are going to be smarter. They're going to get around rules. And so what you want is stupid rules, not smart rules. You want big, broad, basic rules. Glass-Steagall was a very dumb rule. It says banks are banks and investment banks are investment banks and never the twain shall meet. And that served us well for a long time. So you need broad principles in your financial rules, not smart, technocratic, perfectly designed rules. And the other big problem with Dodd-Frank was, and I'm repeating myself, but without the legitimacy of prosecutions, people don't believe that your reform efforts are for real. So what you need to do is combine the old Republican law and order ethos of prosecuting individuals with the democratic technocratic ethos of addressing systemic reform. That's the perfect marriage. And it lends legitimacy to your reform efforts and your systemic changes.
A little Old Testament with some wise judges.
Yes, exactly. Okay. 2 more questions?
This is kind of similar to the second question you got, but any data that you know about where, yes, 1 in 20, 1 in 30 corporate CEOs, it's maddening, it's grossly unfair what they've gotten away with, but the rest of the cases, it does actually, being soft on white-collar crime promotes economic expansion?
You mean, so soft on economic crime promotes economic expansion?
Soft on white-collar crime.
Are there data on that? I mean, I don't think there are. I'm not familiar with any studies about whether it actually helps the economy, but I'd be extremely suspicious because I think that actually strong institutions and the rule of law and fair dealing and expectations that you have the ability to take your case into court actually undergird our financial system. Strong regulation leads to stronger banks and to stronger capital markets, and strong regulation contributes to economic growth. So I would say, a corrupt system ends up eating itself.
There is, I could just help with that question.
Yeah.
There is a lot of evidence internationally across countries where those that have much more enforcement, stronger rules of law, as you said, are stronger economically. Now, the difficult thing to know is what causes what. You can never really know which way the causation goes, but the correlation is there.
Thanks. I wonder if you'd considered either NPAs or DPAs with a little bit of a kind of rat factor, basically the condition pursuant to which a corporation would be permitted to enter into an NPA or a DPA would be a, material support in connection with the prosecution of the CEO at that particular corporation. So
that is written into all DPAs and NPAs as they exist now, which is they all are contingent on continued cooperation with any investigations, and yet there are no continued investigations. And Brandon Garrett at the UVA, I think he's at Duke now, has sort of found that in a book. And so there's a problem there, and it wouldn't be solved with a clause that says you have to cooperate. Now, there was a tacit acknowledgement that there's been a failure to prosecute individuals in the Obama administration with Sally Yates, who was the Deputy Attorney General under Loretta Lynch, the last DAG in the Obama administration's DOJ. And she comes up with a Yates memo that says we need to prosecute individuals, and we can't reach a corporate settlement unless you've also prosecuted an individual, which I think, as I say, was a tacit admission that they've failed. The problem with that is the corporation serves up a middle manager, schmuck. I think schnorrer was the wrong Yiddish there. Schmuck is what I'm looking for, who is thrown under the bus. And the top executives, the really culpable ones, are able to avoid any culpability. So I think the DPA is a drug that the DOJ needs to wean itself off of. I think it has too many malign consequences to be salvaged at this point. I think you could rehabilitate it over time after you had broken your dependence on it.
Well, let's give Jesse a big hand. Thank you so much. It was a great discussion.
Great. Thank you again, Jesse, Paul. Just have 2 points to make before we conclude for the evening and head to the cocktail portion. One, most importantly, there are books available for sale in the back of the room. And two, just want to make a reminder, NYU One Day is approaching. So for anyone who's wants to donate or find another activity, to donate to the school, volunteer work, please contact one of the staff or alumni relations here. And with that, thank you very much, and we'll proceed to the next portion.